Brian Wilson, Mary Catherine Ham, Brian Neiman, today's newsmakers, and you, the Morning Majority. 105.9 FM, AM 630. WMAL.
7:07 on a Monday morning. The gang's here. Brian Neiman, Mary Catherine Ham, Brian Wilson. Joe DiGenova, our legal expert, is on the line. Joe, we've talked about Penn State before, but have you seen other cases where you just shake your head at some of the comments from defense attorneys? The latest, one of Jerry Sandusky's defense attorneys saying, well, yeah, he was showering with kids. He was just teaching them the proper way to shower. They needed to learn proper techniques for good hygiene.
Well,
where does this come from?
As I heard that, first of all, good morning and Merry Christmas to everyone.
Merry Christmas to you.
First of all, as I heard that statement from Mr. Amendola, all I could think of was the Lewinsky lawyer Ginsburg. Remember the screwball lawyer who represented Monica Lewinsky, who was on every television show talking about every aspect of the case when he should not have been? The bottom line is Amendola is unbelievable. This is some of the dumbest lawyering I have ever seen. And, you know, the only thing that you can say is perhaps he's an idiot savant, and he knows something about Pennsylvania judges and juries that we don't, but I don't think that's the case.
I think this was actually the other lawyer. I mean, Amendola said some other things before in the past, so it sounds like he's got two crazy lawyers on it. I do want to ask you about the testimony from Mike McQueary, who in 2002, according to the grand jury report, said that he witnessed actual rape of a boy. And during the hearing for the two vice presidents at the school, Tim Curley, the athletic director, and Gary Schultz, he didn't go quite that far, though he said that he believed he saw it. Does that make a difference? I mean, and how is that possible? Did the grand jury go too far in their, or the report go too far? Did they misquote him, or has he changed the story slightly? And does that make a difference?
First of all, it does make a difference, because anytime a key witness makes inconsistent statements, they can be used to impeach his credibility when he takes the witness stand. First of all, when McQueary testified before the grand jury, it was transcribed. Every word was taken down literally, and he was under oath. He was also under oath in this proceeding and has given different testimony which is dramatically different. He said he believed he saw a sexual assault. Well, that's different than saying you actually saw it. The one thing he did say was that Sandusky was in the shower, nude, with the kid who was nude, and something was going on. To my way of thinking, the key testimony will come from the person who was in the shower with Sandusky. And whatever that boy says, or man now, will be what matters. And McQueary is part of this horrendous group of people at Penn State who worried more about their jobs in the university than they did about the well-being of these young kids. But it's very bad for the prosecution that anything like this would happen, but I don't think it's going to change how bad this is going to look when the full trial occurs.
Do we know the identity of that boy? They had not. Okay.
We do not know the identity of that person now, but that of course will happen when the trial occurs.
I want to ask you about Newt Gingrich. We're going to be asking our audience about it in a moment, but Newt Gingrich has sort of doubled down on these comments about how he would go after activist judges by subpoenaing them to testify before Congress. And this weekend on Meet the Press, he went even a step further, said he would send the U.S. Capitol Police and perhaps the U.S. Marshals to compel them to testify. Now, this is selling in some quarters. But a lot of people look at this, and it sort of raises their eyebrows and concerns. What say you, legal analyst Joe DiGenova?
Well, I'm pretty conservative, but I can tell you right now, this is crazy, and Newt's nuts. This is the most absurd idea. We have an independent judiciary in this country for a reason, so that judges will reach decisions based on the facts and the law and not on politics. By the way, judges have been subpoenaed in the past before Congress to testify about their decisions and have uniformly refused to produce records and documents and testify. In fact, there are some very famous cases where judges have sent letters to Congress and indeed come up and actually testified. Some U.S. District Court judges testified in the House and rebuked the House for asking for their records. This is the worst type of demagoguery by Gingrich, and it's not going to sell, believe me, with real conservatives, just like his attack on Romney over investment banking didn't sell with true conservatives.
One of the interesting things about this is that he seems to be making the case for a stronger legislative branch at a time he's running for executive office.
Well, not only that, the call by others for a part-time Congress, guess what? You want to make the president stronger? Have a part-time Congress.
Yeah, right.
I mean, these guys, I don't know what these people are smoking, but from a good government political science standpoint, these proposals are beyond moronic. Newt is obviously playing to a crowd that I think is going to get smaller and smaller over time. But the irony of all this is not lost on people.
Well, and surely it would occur to people that even if you put aside constitutional issues with this, once you get a Democratic Congress, you're not going to be having the same judges called in to answer for their decisions.
You know, as they say in Gone with the Wind, tomorrow is another day.
Right.
And you just never know who's going to be in charge when it's over. That's why the having a balance of power, where you have three branches, was such a brilliant design, and why we must do nothing to screw up that balance. You know, if a judge isn't good, or if a judge is bad, or, as the Constitution says, does not engage in good behavior, which is the standard for keeping them on the bench, they can be impeached. And we regularly impeach federal judges now for illegal conduct or unethical conduct. But this notion that somehow you're going to get them to come up and force them to explain their decisions is completely inconsistent with our quite highly developed concepts of judicial behavior. By the way, states have laws where they have what are called retention elections, where people get a chance to vote to keep their judges on. This is what happened in California. You remember Rose Byrd, the famous California justice, who made speeches about how much she supported the death penalty, but never voted for a single death penalty conviction. Well, you can't do that in federal courts, but the state courts can, and that's why our system is so great. We have different standards.
Now, Newt's argument is that, hey, before we have impeachment, let's actually hear from the judges to get their side of the story on it. So we'll bring them in, we'll subpoena them, and we can question them. We'll figure out exactly what their rationale was before we get to that step of impeachment.
Yeah, well, that's his notion of a pre-impeachment grand jury. That's never going to happen. None of these judges is ever going to come in and explain their decisions, and they shouldn't. And they're not required by the Constitution to do so. Now, by the way, Newt said some other things, like he wants to abolish certain courts.
Right.
As we said last week, Congress has the right to abolish courts because they set them up, they can take them down. That would be unwise, but nonetheless, they do have the power. They don't have the power to call judges up in the absence of an impeachment proceeding. They can call judges up to testify in an impeachment proceeding if they want to, but they can't force them to testify in an impeachment proceeding either. They can call them up and have them sit there and ask all the questions they want. But even in an impeachment proceeding, a judge does not have to answer any questions.
But can a judge be impeached for anything? I mean,
no. The constitutional standard is, quote, they shall retain their office as long as they engage in good behavior. And the truth is that over the years that has come to basically mean either irrational behavior on the bench, like literal craziness, like Judge Ritter in Utah, or illegal behavior on the bench, like bribery, like Alcee Hastings,
right.
who is now a member of Congress.
Right, who will be questioning.
That's right.
Yes, that's right.
Oh, dear.
All right, Joe, great to have you on as always.